It'll be hard to follow that up. Okay. So the question headlining this panel requires knowing what religious freedom is. The fact that we are having this conference on the topic suggests that the concept can be elusive. Perhaps, however, the phrase itself invites a certain ambiguity. Presumably, from an anthropological and theological point of view, if we take seriously the idea of restlessness or the notion of homo religiosus, we would want to see religious freedom as simply the central truth of freedom as such. But of course, the phrase is not simply anthropological, but also political, juridical. Does the fact that the qualifier freedom is simply, does the fact that the qualifier religious is attached to the substantive freedom then suggest that religious freedom is simply a subspecies of political juridical freedom, which is therefore taken as not inherently religious? If so, then religious freedom would be treated as one of many freedoms rather than as freedom's central truth. Denied from the outset, then, would be that these other freedoms would necessarily have to be iterations or developments of this underlying freedom. Religious freedom understood in this way may very well be considered the first and most basic right or freedom guaranteed by government, but it will still, for all that, be only one of the many rights or freedoms. No doubt, with the growth in complexity and technological power of the modern state, with all the responsibility for human well-being that it has appropriated to itself through its ever-growing regulatory and bureaucratic oversight of human action, these rights and freedoms, whether taking the form of immunities or entitlements, will continue to multiply. Whether this multiplication constitutes an ever-increasing recognition and security of basic freedom, as widely assumed, or rather their diminution through detailed definition and regulation, is another question. In either case, the result for religious freedom, if it is indeed simply one among many freedoms, is that its place in the overall juridical pantheon of liberal rights will grow ever smaller. To see my point, consider Exhibit A, which of course has to be the HHS contraceptive mandate, right? Since it's a theme throughout here. If the foregoing point is accurate, it would go a long way to explaining the problematic presented to the church and her leaders by the controversy. Here the bishops have been maneuvered into a difficult position. The only foothold available in the debate would seem to be the concept of religious freedom. Now, the category of religious freedom would seem to apply on the basis of the mandate's external interference with the church's autonomous order and operation as these relate to employment. However, if it is true that religious freedom's centrality and importance as a civil right are decreasing, so too is its usefulness as a point of leverage. For if, for example, the free availability of contraceptives is part of the logic of women's equal participation and access to the job market, and if the church and religiously oriented entities enter that market as employers, then the claim of religious freedom comes into direct conflict with another fundamental right. How do we mediate between these two rights? As always, mediation implies a more fundamental mode of reasoning, one that can encompass both the competing rights or interests and resolve their conflict by ordering them. Many Catholics would have no problem putting their finger on the precise mode of reasoning for this purpose, the natural law. Natural law would come into play in at least two ways. First, in bolstering the status of religious freedom in relation to other rights. Second, in relation to the merits or demerits of contraception or its legal status. Regarding the first of these, it can be argued that religion is an integral good necessary for realization of both the common good of society and for the well-being and flourishing of individual citizens. Accepting that religious faith must never be, indeed in principle cannot be, coerced, that therefore citizens must be free even to reject religion, we could argue nevertheless that if religion is a basic human good, it both spawns and orders other foundational personal and cultural goods. Hence, We might conclude religion has a unique status in society and ought to be accorded special protections, perhaps having priority even when it comes up against other competing rights. Unfortunately, this sort of argument plays well only to certain Catholic audiences and seems to have at best a diminishing cogency for contemporary culture as a whole. Indeed, thoughtful non-believers or atheists would likely conclude that, far from being a public good, religion is a public bad, and one from which the citizenry ought to be weaned. So, while this understanding of the issue may seem almost obvious to many of us, it simply falls on deaf ears in the broader debate, which after all is the debate raised in the current controversy in Exhibit A. The result is a continuing repetition of arguments that seem mysteriously to have little traction. The central question I would like to pose is why this would be so, although I have already hinted at what I think might be part of the answer. Of course, pursuing the debate along these lines presupposes that the question really is one concerning religious freedom. Oddly enough, few seem to have noticed the paradoxical aspect of this way of engaging the debate. While the Church and her leaders feel constrained to employ the category of religious freedom, the question of the goodness or badness of contraception as such is thought by Catholics to be one of natural law. Hence, many Catholics would think that this issue is not precisely a religious one if we take the word religious in a narrow sense. After all, the rejection of contraception is not thought to be a special Catholic morality, but a universal truth about the human person. Hence, one might have assumed that church leaders would approach the question from the standpoint of the goodness or badness of contraception rather than from the standpoint of religious freedom. This, of course, would then lead back to a debate about the relationship between law and morality, or civil law and natural law, perhaps not regarding whether contraception ought to be legal or illegal, but regarding whether, given its harm to persons and society, it ought to be mandated service at all, and, in that vein, whether government should or could force institutions, Catholic or otherwise, to subsidize it. Again, that the category of religious freedom is employed here suggests that church leaders have set aside, for purposes of this controversy, the substantive question of contraception's goodness or badness, whether for individuals or society as a whole. Instead, they have accepted the culturally reduced conception of the issue to the simple assertion of ecclesial autonomy in fundamental beliefs and, in this case, how those might or might not affect employment practices. However, the Church has never claimed exemption from all civil laws. Why should she have an exemption for this one? Inevitably, then, we are led to the second way in which the natural law reasoning might be relevant to this controversy, the one dealing with the moral status of contraception as such. So the logic of the situation from the Church's point of view does indeed suggest that some natural law reasoning on contraception itself is lurking in the background of the claim for autonomy. The mandate is very different from, say, a requirement that employers, including religious ones, provide retirement benefits precisely because of this background natural law conclusion. The church leaders have not publicly pursued this line suggests that, at least in their considered judgment, they cannot. Evidently, natural law arguments concerning the substantive issue have even less plausibility for the culture than those for the primacy of religious freedom. That the category of religious freedom must be invoked is therefore revealing in itself. If the question cannot be approached from the standpoint of the underlying natural law truth concerning the merits or demerits of contraception itself, then the question has to be approached purely at the level of the authority of the government to force compliance with its regulations. Hence, the problem, apparently, can only be dealt with by the Church as a question of relative authorities, of institutional power and autonomy, rather than as a problem of truth and goodness. If the Church's position both implies a natural law argument in the background concerning the merits, but is forced to treat the issue as one of autonomy and governmental authority, we are left with a kind of irreducible tension in the Church's position. In effect, the Church must act as though her teaching on contraception can be treated as a bit of exotic and basically non-rational and probably inhuman Catholic morality. In other words, her response would seem to be reduced to this: we do not expect you to understand our belief, but only to respect it as ours. But if natural law reasoning is not able to gain a foothold, it cannot serve as a way to mediate between conflicting rights, as we started off assuming. Rather, it is reduced to constituting part of the contents of one of the worldviews seeking protection, and a content that is assumed from the outset to lack a rational basis. On the other hand, there is another kind of rationality that seems to offer a resolution to the conflicting rights: religious freedom on the one hand, and equal access to health care services, or full participation in the workforce, or equal care and consideration for the sexes on the other. And it is this second type of rationality that does, unfortunately, have sufficient cogency to carry the day. This alternative views the conflict of rights as that between what are treated as ultimately irrational particularistic beliefs, or theological or metaphysical or moral truth claims, it amounts to the same thing, and what amount to publicly rational concerns for equality of access to social benefits. Once the debate is framed in this way, it is clear which set of rights will prevail. The argument for religious liberty, in other words, is likely to lose at the end of the day, precisely because it is unable to express its deepest foundations in a manner that is cognizable as a form of public reason. Again, my question is why? This topical controversy highlights a very fundamental problem in trying to understand the meaning of religious freedom. It is a problem of admissible forms of public discourse, given the culture generated by political and juridical liberalism. The foregoing suggests that this difficulty arises most especially with respect to the question of the human person. The Church understands herself and her role in the public square as an expert in humanity. Yet, or perhaps therefore, it is no accident that the issues the liberal culture and the Church have with each other all seem to turn precisely on questions presupposing differing visions of the human person. At the same time, the lack of means for the Church even to establish her autonomy and interior ordering in the instance of the HHS mandate rides on her inability to present a publicly cognizable vision of the human person. If it is fundamental to Catholicism to offer form to culture, this form is rooted in her conception of the person. But political and juridical liberalism proves itself entirely resistant to the form. Now, to address this question as to why this is so, we need to get a bead on public reason in the contemporary context. I had a paragraph on Locke, but for time's sake, I'm cutting that. Perhaps the most influential political philosopher of our day. We probably can find no better place than in the work of John Rawls, perhaps the most influential political philosopher of our day. If liberalism is often justified as a necessary response to the seemingly obvious fact of pluralism and its explosive potential, Rawls, on the other hand, tells us that it is a civil good produced by what he calls, in his book by the same name, political liberalism. As he puts it, pluralism is a natural outcome of human reason working under liberal institutions. Far from being a disaster, therefore, pluralism is a sign of a healthy political order in the society it produces. It is the product of citizens each arriving at their own comprehensive notions of the good and the true. Indeed, this is the fundamental task of the citizen at the basis of Rawls's understanding of persons as moral beings. It is one's vocation, we might say, to give oneself a vocation, one's end to give oneself an end. It is precisely this placement of freedom at the origin of personality that is thought to prevent the tyranny implied by monism. But this thesis is rooted in an implicit conception of the relationship between freedom, truth, and good. Indeed, this placement of freedom implies a certain understanding of freedom. Truth and good are envisioned not as freedom's interior order, but as an external limitation. Freedom, therefore, is conceived as empty or indifferent freedom, a freedom conceived as most essentially unimpeded choice between A or B, X or Y. Because for Rawls, our task as persons is to give ourselves our vocation, This unimpeded choice is the basis for arriving at our conception of ultimates, answers to the large questions concerning the meaning of things, especially human things. Hence, Rawls's placement in the political order of the concept of freedom entails a prior judgment about the nature of freedom as such, a judgment that works its way through the political anthropology, partly buried in his thesis. Now, Rawls also conceives political liberalism as a political morality. He insists that principles of political liberalism should be understood not as the terms of a modus vivendi, but rather as the basis for arriving at a properly political and fair notion of justice. It first of all makes people better from the vantage point of several social or political virtues. Because pluralism surrounds citizens with multiple notions of the good and the true in the whole sense, it results in citizens becoming more liberal, more tolerant. But as a political morality, it also offers the form of public rationality. These features of his thought raise the question of whether the Rawlsian idea of political liberalism does not itself, very much against his intentions, represent a particular view of ultimates, the true and the good, not just political truth and good, but also fully human truth and good. The public rationality to which it gives form, then, would in fact be rooted in this conception of the fully human, true, and good. It would be rooted in an implicit conception of who and what the human person is. The human person is one who is a chooser before he is anything else. I say against intentions because it is the very point of political liberalism that it seeks to mediate the ways in which differing and even competing notions of the whole human truth and good, what he calls comprehensive doctrines, may interact to arrive at a political sense of justice without favoring or imposing any one of them. At the root of Rawls's thought, then, is the principle that properly political and properly public reasons can never themselves be the embodiment of one particular comprehensive doctrine. Rather, for Rawls, the properly political, that is to say, properly public reason, is always justifiable independently of any particular comprehensive doctrine. While it is fine to express one's views on the just in comprehensive terms, at the end of the day, that conception must be rationally severable from comprehensive belief and yet remain politically cogent. This is what Rawls calls political liberalism's proviso. Of course, the proviso means that comprehensive doctrines, if they are to remain part of a properly political discourse, must be the sort of comprehensive doctrines capable of detaching public reasons from the question of the comprehensive good or true. The implications of this last point become clear when Rawls explains the nature of the terms of engagement citizens offer each other in setting forth a political notion of justice. In order for citizens to participate in political discourse, they must hold reasonable comprehensive doctrines. Reasonableness, we are told, means offering and accepting fair terms of cooperation. Of course, any decent religion, philosophy, or general human outlook should presumably embrace fairness in human interactions. But when Rawls speaks of the unreasonable, another side comes out. Unreasonable comprehensive doctrines are characterized as those holding that the political is concerned with the whole truth. That is to say, unreasonable doctrines are those that think that the political in some sense is about or takes its concrete form from within or is rooted within the whole truth. As he puts it, political liberalism views this insistence on the whole truth in politics as incompatible with democratic citizenship and the idea of legitimate law. Hence, he concludes that those who seek to effect such an imposition simply cannot be part of political discourse. Of course, Rawls points in this context to those who would simply use political power to impose their views on an unwilling population. However, Rawls's thought here implicates more than just tyrants and dictators. Indeed, the question of the whole truth is only a variation on the central principle of liberalism in its dominant forms, that the political cannot be about comprehensive truth or good. Hence, the exclusion from political discourse of those who would include the whole truth in the political is simply a way of expressing a basis for public reason according to the logic of liberal views. So we might offer a proposal concerning human goods given our comprehensive background, but we must ultimately present those goods insofar as they are to be politically or juridically relevant according to the standards of public reason. Now, public reason effectively has to be essentially liberal public reason. That is to say, public reason that presupposes the primacy of freedom and unimpeded choice for self-actualization. Hence, for proposed goods to be publicly or politically or juridically relevant, they must be goods rooted in this indifferent sense of freedom. To put it another way, those comprehensive doctrines that are not capable of being that are not capable of expressing their views in the political and the just, except as elaborations of their deepest convictions about non-liberal truth and good, will always appear unreasonable, unless, of course, they give up on the political altogether or give up on the relevance of their convictions for the political. We might call this the Amish solution. To be Amish is to be free. Now back to Exhibit A. As I said, the problem for the church is her inability to express the bases for her claim to religious freedom in a manner that can serve as an acceptable form of public reason according to the liberal order. She could offer natural law reasons as public reasons for seeking exemption from the mandate. But her natural law reasons would depend on proposing human goods, such as the good of religion or the good of the person in relation to the bad of contraceptives. But these goods would be very hard to advance in a way that does not presuppose the ability to express in public reason quite a lot about who and what a human person is. For example, it would likely be hard to argue that contraception is at least morally suspect if we cannot say something about the integrity of the human subject as corpore et anima unus, rather than as simply a subject of self-actualizing freedom. But as we saw, we cannot say much of anything about this fundamental question. If we cannot say much of anything about this fundamental question, then the question of religious freedom becomes simply the assertion of a non-rational right to autonomy over and against another right that is readily expressible in terms of liberal notions of legitimate public reason. Now, implicit in the rejection of the political being about the whole truth is the further rejection of the political being about who and what the human person is, as I've already suggested. Liberalism's priority of freedom over questions of the whole implies a deferral of what questions. In this case, and most especially, questions concerning who and what a person is. To say who and what a person is, to settle on nature or anthropology, would entail a settlement of the question of the comprehensive notions of the true and the good. To say what something is to suggest an answer to the question of what its perfection or fullness or good is. It would be, therefore, to settle the question of the whole truth and the whole good. In effect, therefore, the freedom to choose one's own comprehensive doctrine entails the freedom to arrive at just such an understanding of the truth of the person. Hence, as I said, political liberalism envisions the political and juridical purpose, for political and juridical purposes, the person is a chooser before he is anything else. Liberalism and its form of public reason presupposes that my freedom is most especially realized in my decision about who and what I am. Now, this placement of freedom implies a general approach to reality as a whole. Again, for political juridical purposes, it implies, for example, that liberalism will necessarily favor empirical over metaphysical bases of knowledge. Because in looking at the world, it will seek to understand things, including human things, in abstraction from given formal and final causalities. It is therefore no accident that the issues causing the greatest discord between the church and the liberal culture are all those that, in one way or another, involve the meaning of what a human being is, especially with respect to our physicality, our embodiedness, and so forth. In other words, or, for example, the question of the meaning of sexuality and the role of women in society and the church, which are the immediate background of the mandated insurance coverage for contraceptives. These issues most immediately disturb the reigning conception of freedom as its own source, of the physical as only mechanistic and empirical order, of the separation of fact and value. The body, in its very physicality and visibility, always threatens to name me, to tell me who and what I am. As such, it produces angst. It threatens to ensnare my freedom either in the mechanisms of subpersonal matter or in the impositions of a creator God. Of course, not every liberal thinker is Rawls. Hence, it may seem that the discussion of Rawls does not yet say anything about a more moderate, more conservative, and Catholic version, which would see the necessity for liberalism of a strong moral support, a moral support that would have its source not at the level of the political, but at the level of society. Religious freedom, along with other rights, would precisely protect this sort of moral formation of society, but the liberal political order would depend on it. Unfortunately, however, such Catholic versions of liberalism also rely, at the level of the political, on a priority of freedom understood as abstract choice. Hence, when John Courtney Murray frames religious freedom in purely juridical terms, he sets out principles or a kind of political anthropology. His anthropology is contained in 5 principles. The first of these is framed in terms of human dignity, rooted in independence, man's being in charge of himself. This correlates with another of his principles, which he calls the principle of a free society, that man in society must be accorded as much freedom as possible, and that freedom is not to be restricted unless and insofar as is necessary. Another of the principles is that public power's first and principal concern for the common good is the effective protection of the human person and its dignity. However, as we just saw, this dignity is put in terms of independence. My question then is the sort of public reason this starting point in freedom, or the kind of freedom it presupposes, is likely to produce. Hence, one is free to introduce natural law reasons as public reasons, but unless those natural law reasons can be expressed in terms of the priority of freedom and all that priority implies, liberal notions of public reason will drain them almost entirely of their rational content. And this will be true for a host of issues that bedevil the Church's relationship with the rest of society, from the HHS mandate to gay marriage to the question looming just on the horizon concerning the bioengineering of the human person. The liberal conception of religious freedom codifies an understanding of religious freedom as one freedom among many others, but a freedom whose content is inarticulable as a public reason and is therefore at a loss when confronted by competing claims that can take the form of a liberal expression of freedom and its anthropological priority. The result is not only the current narrow basis for the Church's public presence, but also a diminution of the intelligibility of the Church's conception of the person, both to the culture generally and also to the faithful themselves, who, after all, are part of that culture. And this is why liberalism's protection of religious liberty is highly suspect. Religious belief, in fact any belief, remains free only insofar as it can be expressed in the image and likeness of liberalism. Thank you.